My name is Amber Hines, and I'm the owner of Ashburr, where we specialize in Medicaid compliant annuities. And I'm really excited today to be doing a co-presentation with Attorney Todd Whatley from Arkansas. We're going to be talking about how to plan with IRAs and Medicaid annuities and different options that would be available if your clients have tax qualified funds. Todd, I'll let you introduce yourself and then I can talk a little bit about myself.
Sure. Yeah, my name's Todd Whatley. I am just about to pass 27 years of practice, which surprises me. It seems like yesterday almost, but I am a certified elder law attorney. I have also gone to Stetson University, got my LLM in elder law, and I am also the founder of the Elder Law Coach, which provides coaching to attorneys across the country for basically everything elder law. And I'm excited. I have an event coming up in February that we will talk about at the end of the slideshow, so don't leave, okay?
Awesome. Thank you. And I'll just touch a little bit on some of the things about myself. So I have been in this industry for 20 years now, working with elder law and estate planning attorneys to secure Medicaid annuities for their clients. I am insurance licensed in all states and also hold my Series 65 license with FINRA. And I really created Ashburr to assist attorneys as well as financial advisors with annuities and pre-planning long-term care policies for their clients when we have somebody that's healthy enough to qualify for those types of contracts. If you are interested in the handouts from today's presentation, I forgot to mention, but a copy of those are in the GoToWebinar dashboard handouts portion. And then also, if you have questions during today's presentation, feel free to type those into the questions bar of the GoToWebinar dashboard as well. So some of the reasons why attorneys and other advisors will choose to work with Ashburr is we do provide complimentary case analysis to the law firms and the agents that we work with. So we will help you to determine the correct amount of the annuity to purchase, the different terms of annuities that may be considered for your clients, and then also the types of assets that we may consider moving in order to preserve those assets in order to be spent down for Medicaid. We do offer lower fees for our annuities as well, and we offer great experience, top-notch customer service when we are servicing law firms and agents with the purchase of annuities for their clients. Today, we're going to be talking specifically about Medicaid crisis planning. So somebody who is already in a crisis scenario, they're already looking to qualify for Medicaid by protecting their assets or spending down their assets. Todd, do you want to talk a little bit about the planning goals that we have in mind when we are doing crisis planning for clients?
Sure. Yeah, and a very high level process here is we're converting convertible resources. Okay, so there's non-countable and there's countable, and we'll talk about those in just a second. But the overall goal of crisis Medicaid planning is we've got to get these countable assets that are causing this person to be disqualified. We've got to get those to be either no longer qualified, fit within those non-countable assets, or we convert it to income, which thankfully, and we'll discuss, but the community spouse, particularly with a married couple, the community spouse can have unlimited income in most states, okay? And so part of our goal is to convert assets that are causing disqualification to be either a non-countable asset or income. Very simple, okay? And by doing this, we are minimizing a state recovery, because basically the person going on to Medicaid has nothing, and we take steps to make sure they truly have nothing, so at their death the state can't come back and put a lien on it. So with a married couple, what we are looking at is we're looking at both of their assets, and like I always tell my couples, and particularly when I'm speaking in the public, the bad news is If you're married, Medicaid's going to count the assets of both spouses. They do not care if you've been married 6 months or 60 years. If you're married, they're going to count the assets of both spouses. You will have people call and say, oh, no, we've only been married 5 years. This is my money. This is his money. They can't come after my money. I'm like, yes, they can. Okay. And people freak out. They're like, oh my God, no, they can't do that. It's like, come see me. Let's talk about it, because with these techniques we're going to talk about today, we will be able to protect large sums of money. Now, we've got to rearrange those assets, but we can protect it. And so that's what we're talking about, is figuring out how much does the community spouse have, how much does the institutional spouse have, and then how can we get it from the IS to the CS without breaking the rules, okay? So the institutional spouse has to be down below $2,000, and the community spouse on paper can only have just under 158, 157,920. Okay, so if you've got a couple with $1 million, one gets 2, the other gets 158. What do you do with the other 850? That's what we're going to cover today. Okay. So this is the list of non-countable assets. Okay, this is the, this is supposed to be Amber's, but I'll just do it real quick. So the non-countable assets, the 4 big ones that apply in every state is the home, the automobile, the household goods, basically anything that's in the house, in the storage shed, whatever. And then an irrevocable funeral trust. Okay, those are the 4 things that always work. And then in some states, IRAs, either for the IS or the CS or both, in some states is not counted.
When we talk about the different types of retirement accounts, Medicaid is really going to be looking at either a traditional IRA or Roth IRAs, 401ks, or 403bs, and these are just the IRS section codes that describe each one of these retirement accounts, but they basically are going to be treated differently by Medicaid if you do have clients that have these types of accounts. The 401k and the 403b are going to be the employer-sponsored plans that we would be able to plan with in order to preserve Medicaid eligibility for these clients. When we look at the difference between a non-Roth account and Roth accounts, the non-Roth accounts are going to be what you think of when you think of a traditional IRA or a 403b, 401k, where we have pre-tax money that is going into the retirement account. There's not going to be any income tax on the earnings, so it's going to grow tax deferred, and the income tax is not going to be due until the money is either withdrawn, surrendered, or if we annuitize it, then the money would be considered taxable as the annuity does make payments. Whereas the Roth accounts are going to be after-tax dollars that are used to put into the Roth accounts. There are not going to be any income tax on the earnings with a Roth account, and there also is not any income due upon receipt with a Roth account either. So it's really a matter of pre-tax accounts versus after-tax accounts when we are looking at retirement assets.
Yep. So the plan here, you know, and the issue here is we are dealing sometimes with a pre-tax asset. And what's nice is some states treat retirement accounts differently. Okay. States take one of these 3 positions. Number 1, it's completely exempt. Since it is an IRA qualified plan, it is completely exempt. You don't have to worry about it. You don't have to do anything with it. Okay. Number 2, they exempt IRAs if they are in payout mode. Okay. Meaning that they've, you know, at 59 and a half, I think you can start RMDs, you can start withdrawing from this, but at, I think 73, you have to start taking RMDs. And so if the IRA is in payout status, meaning you are taking RMDs from it, then it is a non-countable asset. And then the third, which is the state I'm in, is that the IRA is an available resource. It is counted. There is no exemption of it whatsoever. So we have to do something with it, which makes this planning very difficult. Okay. And you also have to know who owns which one. Okay. And you probably know this, but just to make sure, IRAs are not jointly owned. Clients will tell you, oh yeah, this IRA is jointly owned. No, the IRA, the I in IRA stands for individual. It is owned by the individual and not jointly owned. So it's very important that you understand who owns which one.
So planning is going to be the most complicated in states that consider the retirement account to be an available asset. And the reason is just because you're more concerned about the tax consequences related to pre-tax accounts. So most of the country from a Medicaid standpoint does consider the qualified or the retirement accounts to be countable assets. There's 40 states currently that treat the retirement account as a countable asset.
Yeah, Amber's done a really good job here. This is one of those handouts that you're going to want to pay attention to. Find your state and see if it's here. But this is where the institutionalized spouses account is countable or exempt. And so the brown, orange, whatever that is, it is completely exempt or exempt if receiving systematic payments. So this is the person in the nursing home. Okay. The next slide shows how they are, that the community spouse IRA is either completely exempt or exempt if receiving systematic payments. And so that's really nice because it really stinks when the community spouse, she is not the one, typically it's a she is not the one going into the nursing home. If she can leave her IRA completely alone, that's a fantastic situation. But like my state, we have to do something with it, and that stinks. But it gets them qualified, okay? All right, so why is Medicaid crisis planning with retirement accounts so complicated? Taxes, okay? This is money that has never been taxed, and people love their IRAs while they're working. It's like, yay, I've reduced my income. This money's out here, it's growing. I don't have to worry about it. But there's a huge tax bomb sitting in that account, and it particularly becomes an issue when the person needs to go into the nursing home, and we've got to get them down below that $157,920 plus $2,000. And so that's what makes this so complicated, but we're going to walk you through it, okay?
So if IRAs are countable in your state, we're going to develop a Medicaid eligibility plan that is going to either involve liquidating the IRA and paying the tax, or converting the IRA into an IRA Medicaid compliant annuity. And this is going to depend on a variety of factors, such as the client's age, their anticipated longevity, and then the size of the IRA account. Those are all going to be things that we look at when determining what is the best solution for, or the best outcome for that client. Does it make sense to liquidate or to convert that into an IRA Medicaid compliant annuity? When we are planning with IRAs, if we do have just an individual that does not have a spouse, so they're not married, we can look at doing a gift strategy with an IRA Medicaid compliant annuity. With an IRA having different rules from an annuity standpoint, we can either make that a balloon style annuity, or we can do a level payment on the IRA Medicaid compliant annuity for an individual. We have a separate webinar on that topic, but there are opportunities with individual clients that aren't married to do an IRA Medicaid compliant annuity as well. And then when we're looking at married couples, which is what we're primarily going to be focusing on today, we have a variety of different options. We can either liquidate the IRA, pay the tax, and purchase a non-qualified or an after-tax dollar annuity for the well spouse or the community spouse. The second option would be to purchase an IRA Medicaid compliant annuity in the name of the institutionalized person, so we're not changing ownership on the IRA. The third option would be to use an IRA Medicaid compliant annuity in the name of the Medicaid applicant and name the community spouse as the payee, otherwise known as the name on the check rule. And then the fourth option would be to use a marriage quadro, which may be available in your state as a way to convert retirement accounts from, or transfer retirement accounts from the Medicaid applicant's name over to the community spouse's name through a court order and not require the married couple to get divorced. So our next webinar in November is actually going to be on that topic of a marriage quadro, which states that works in, and so look out for the upcoming webinar information about that.
Hey, Amber, let me say real quick, go back one slide real quick. So on the gift and annuity, if Amber will help you figure out with this much money, how much should be gifted, how much goes into the annuity. If you want a form, if you want to be able to do this on your own, that is complicated. There is a formula. I have what I call the golden formula worksheet. It lays it out. There's lines, say fill out this blank and this goes here and this goes here. I think it really does take a very complicated subject and make it understandable, but that's not the topic of this today, really. But if you do have questions about how to determine the amount of the gift and then the amount of the annuity, I have a form for that. I will give you that information at the end of the seminar. Okay.
Great.
Okay. So the issue here is change of ownership. Okay. Typically, a gift from one spouse to the other is a non-countable or a non-penalized gift. And so we can easily give the house, give the car, give bank accounts, give everything to the spouse, except with an IRA. You can give it, but that is a taxable event. And we're going to go over this and show how to minimize that tax. Sometimes you just want to completely do it and pay the tax up front, but many times you want to stretch this tax payment out because you will be in a lower tax bracket and it comes out better. But you can't gift an IRA to the spouse without tax implications. Okay.
Okay, so we're going to go through a planning scenario that involves IRAs, an IRA that is owned by the Medicaid applicant, and we also have another spouse that is in the community or at home. And so our first scenario would be a institutionalized spouse who owns an IRA. Todd, did you want to go through the case facts on this one?
Yes, please. Okay. The next slide. So husband and wife, Roger is 85, has dementia, resides in a nursing home. So we have a snapshot date. His income is $2,000 and his nursing home bill is $10,000 a month. Nancy is 83. She's the community spouse and she has $1,000 worth of income. They have a home, which is non-countable, a car, non-countable, $325,000 in countable assets. And of that 325, 100,000 of that is an IRA owned by Roger. Now, just a practice pointer real quick. These people are going to come into your office typically if they have talked to people at church or people at the beauty shop or whatever. They're going to come in and, it's probably Nancy coming to see you, maybe with the kids. She may think she's going to lose everything, okay, because everyone understands he's got to be under $2,000. They think that is the number, and they will come in extremely stressed out, and she is worried to death that she's going to lose everything. But she doesn't have to, okay? And how we do that is, and if she does nothing, just like I said, if she does what the nursing home tells her to, hey, you have $325,000, that's too much money, you've got to pay, and she just gets used to paying, she pays until 32 months later and he's broke. And she doesn't have to do that. We can get him qualified within a month, okay? But thankfully she comes in to see you and she's going to keep everything rather than spending everything, having very little income, and basically losing all of her cash, okay? I have even had clients sell their home to pay for the nursing home because that's what they were told to do. So just understand the mindset that these people are coming in. So under the rules, how we calculate the spend down is Roger. So there's a snapshot. So the day he goes into the nursing home, we look at all of the countable assets, okay, which was $325,000. So of that 325, Roger's got to be under $2,000 before we can get him qualified. Nancy only gets to keep $157,920 of the 325 because that is less than half of 325, so she gets to keep that. All right, she gets to keep the home and car, personal property, prepaid funeral. Those are the non-countable assets everywhere, and she only gets $157,920. So therefore, they need to spend down $165,000. Okay, how do we do that? Right. So the 165 is kind of easy to do. If it were not IRAs, we would just spend money on the home, on the car, on the prepaid funeral. We would get those things fixed, redone, whatever. I've had people sell their car, go buy a new car. A lot of people don't have prepaid funerals. Go to the funeral home, write a check, pay for it, get it done, make sure it's irrevocable, or we can call Amber and say, hey, we need a funeral policy. She will work with you, sell you a policy that meets the Medicaid guidelines, and they can put this amount of money into this policy, and it works at any funeral home. Okay, so definitely do those three things: home, car, funeral. Get those things fixed, paid up, done. Then we still have money left over that needs to be spent. And so what do we do with this, particularly with this $100,000 IRA? All right. So in most states, Roger's IRA is countable, and owning that is going to, continuing to own that is going to be a problem. And it's all pre-tax money. So what do we do? Okay. Am I past my limit?
No, you're good. I touched on the three options that we're going to go through. The first was liquidate the IRA, pay the taxes, shift the money over to the community spouse. The second is to keep the money in the name of the Medicaid applicant and have him be the payee. And then the third is use name on the check rule if that is allowable in your state. And we basically are using an IRA Medicaid annuity in the name of the Medicaid applicant, with the payments being shifted to the community spouse.
Yep.
So the first option, Todd, do you want to go through this of liquidating the IRA?
Yeah. So this is going to cause panic among everyone besides you, okay? Because we don't liquidate IRAs. You just don't do that. You never do that because of the taxes. Well, the problem is you've got a $10,000 a month nursing home bill going on here. And so one thing that I will refer to, and I did not get these to Amber early enough for them to be part of the handouts, but you can either find this or I can send it to you, and it is the IRS tax tables. Okay, you need to have it for single people and for married people, because this is going to be crucial when we cash in a $100,000 IRA. It's as if they've been paid $100,000, and they're going to pay income tax on that. And if you don't know what the tax tables are, you're going to say, well, I don't know what that is. But based on this table, with a married couple, $100,000 gets them into the 22% tax bracket. Now, they aren't going to pay 22%. You pay 0 on the first 11,000, 12% on between 11 and 40 cents. But let's just go with 22. Let's just say he pays 22% tax on this. Okay. The next slide. So if you liquidate this IRA, they're going to pay $22,000 in taxes up front. And that's going to, the financial advisor is going to throw a fit. And here's my response to them. If they're like, oh, we can't do this, it's like, well, we have to get his nursing home paid for. Yeah, they're going to pay $22,000 in taxes, but we're going to get the nursing home paid for, which is $10,000 per month, 2 months, and that tax bill's gone or equalized, and then we're making money from this point forward. And so the benefit of doing that is that 22,000 hit to the IRS comes out of his column. We'll see in a second, we can actually convert this IRA into a qualified annuity, but every one of those payments to him or her is going to be taxed, and it's going to be an issue. And if it's coming to him, all of that's going to the nursing home, which forces her to pay the income tax out of her money. By doing this, this gets the income tax done and over with, it's paid for, and it comes out of his portion of the money. Okay, so now we take that $78,000 and we can put that into a after-tax annuity, and that money pays directly to her with no tax complications.
Yeah, the other thing I was going to mention too, Todd, is it really kind of depends on the size of the IRA. If the Medicaid applicant owns a $5,000 or $10,000 IRA, you're probably just going to liquidate that and transfer that over to the community spouse. So it's not always the right answer to try and preserve the IRA that's in the name of the Medicaid applicant, just depending on the size of the account. So sure. If we look at the spend down amount, in this case, after taxes are paid up front, we would be looking at around $143,000 that would go into an after-tax dollar annuity for Nancy. Nancy is going to be the owner of the annuity and the payee. Based on her Medicaid life expectancy at 83 years of age, she has around 93 months of remaining life expectancy. So this is going to be the longest annuity term that we could do for her. We, in practice, usually see much shorter annuity timeframes for a community spouse. Todd, I think your rule usually is around $10,000 a month that you're looking to generate from the annuity just to get that money back to the community spouse as quickly as possible, with the state likely not having a right to recover on that spousal annuity.
Yeah, so if this were my fact pattern, I would recommend doing a 15-month annuity, getting that thing out and to her as quickly as possible. But again, you have to be careful with the tax tables, okay? So you've got to be aware of that. You really don't want to throw, you can get them into the 24, so the next tax bracket for a married couple is between 201 and almost $400,000 a year. That's a 24%. That's just 2% more. And so you're not going to pay that much more tax than they would otherwise pay by bumping into that. But if you go past the 24, the next tax bracket is 8 percentage points away. So you really want to stay under that $400,000 a year in payment. But I don't want the annuity payment to be too big, because I don't want Medicaid to be offended by a $30,000 or $40,000 a month annuity payment. Say, wait a second, we're not going to let you do that. And so I keep mine at the current cost of nursing homes, which in Arkansas right now is about $10,000 a month. And so I would have done this annuity in probably 15 months.
Mm-hmm. Yeah, it's really rare that we see full life expectancy annuities for community spouses, just so that we can avoid having the state recover on the spousal annuity. When we look at the parties to the community spouse annuity, Nancy in this case is going to be the annuity owner, the annuitant or the measuring life, and then also the payee. And the state Medicaid department is likely going to be the primary beneficiary to the extent that Medicaid benefits are provided on behalf of Roger. There are a few states that do allow for the Medicaid applicant or the institutionalized spouse to be named as primary beneficiary before the state. And if you are in one of those states, then there would be additional planning that we could do if the Medicaid applicant is named before the state agency. The contingent beneficiary is usually going to be the children, a trust, or whoever they want to name as a contingent after the state Medicaid agency.
Yep.
When we look at the income calculations, we generated additional income for Nancy, the community spouse, of around $1,700. So when we add that income from the annuity to her Social Security at $1,000, she's going to have total income in this case of $2,663, which exceeds the monthly maintenance needs allowance that Nancy has on her side of the equation. And so she is not going to receive any of Roger's income through the MIMNA shift or the diversion of income. So his copay to the nursing home is going to be his Social Security at $2,000 less the $50 personal needs allowance. So he's going to pay for his care on a monthly basis around $1,950 per month.
Hey,
when we look at, go ahead.
quick, let me just add there, that's another reason to pay this out quickly, is after 15 months, she's back down to $1,000 a month. Now she gets to pull from him almost $1,600 a month for her. And so it just, I'm actually filing a complaint against a law firm that, you know, did not do this. And so I'm very fresh on this, explaining why this is not a good idea, because she loses out on getting her money back quickly and that $1,600 additional income to get her up to the MIMNA. Just doesn't make sense to stretch this out over a very long time.
Mm-hmm. Yeah, so if we look at what the couple was expected to pay, around $10,000 per month for Roger's care, by doing the annuity in Nancy's name, we were able to reduce the copay down to $1,950 per month. So they're going to experience a savings of around $8,050 per month by putting this strategy into play.
Yep. So the advantages of this, it's very safe. Okay, we know Medicaid will accept this strategy. Roger is immediately eligible, and these people leave your office thinking, "Oh my God, I'm so glad I came to see you, because I was thinking that I was going to lose everything and we were going to have to pay for the next 32 months." They don't. We can get them immediately qualified, or the first of the next months. Now, disadvantages, we did have to pay $22,000, and if people really freak out about that, tell them, look, someone's got to pay this tax on it. It's either one of you or the kids, if you want to leave it to the kids. If he dies soon enough that we can leave this to the kids, they're going to pay tax on it, and probably in the same tax bracket that we just discussed. We are going to throw them. The other table that I have is the Social Security. That's at the bottom of this page. It is going to force some of their Social Security payments to be taxable, but it's 85%, only 85%, and at their tax rate, which is still not that big. And it's just one of those things. It's a downside to getting $10,000 a month worth of benefit. Okay. And Nancy, during the life of this annuity, is not going to receive any of his income, which again is a reason for speeding up the payments and getting it done as quickly as possible.
Okay, so the second option that we're going to look at then, instead of liquidating the IRA in the name of the Medicaid applicant, would be to do an IRA Medicaid compliant annuity that is owned by the Medicaid applicant, and he would also be the payee. So instead of liquidating the full $100,000, paying the taxes up front, we could consider doing a $100,000 IRA Medicaid compliant annuity that is structured over his Medicaid life expectancy. So by converting the IRA at $100,000 into an IRA Medicaid compliant annuity, it's no longer going to be considered a countable asset, because we're converting the $100,000 from cash into an income stream that would be basically income to Roger now instead of a asset. We would basically have to do two separate Medicaid compliant annuities, because we can't commingle or mix pre-tax dollars and post-tax dollars in one annuity, because the payments are going to be considered, they're going to be taxed differently as the annuities make payments. So with Roger's $100,000 IRA, we could do a direct transfer of the IRA over to an IRA Medicaid compliant annuity, or a rollover, a 60-day rollover of the $100,000 account into an annuity that would be owned by Roger. His Medicaid life expectancy, based on being 85 years of age, is around almost 6 years or 69 months would be the longest time frame we could use for him. That would generate around $1,500 a month of income for Roger. And then Nancy would still have, if you remember, the spend down amount was $165,000. So we still have after-tax dollars that we need to spend down. And if that's not done by purchasing a new car or making home improvements or funeral planning or anything like that, then we could do a second non-qualified annuity in Nancy's name. Most likely we're going to do this for a shorter time frame than the 93 months, but that would be the longest term that we could do for Nancy based on her life expectancy. The other thing that I'll mention here when we're talking about using either a direct transfer or a rollover would be the timing of when we're trying to get this done by. So if we're looking at, say today is October 15th and we want to have this money converted into an IRA Medicaid compliant annuity by the end of this month, so that Roger would be eligible by November 1st for Medicaid, we're likely going to do a 60-day rollover of that account, because the transfer can take 2 to 3 weeks to actually get that completed, because the company that we're using for the Medicaid annuity is going to request the money directly from the current custodian. And it's really up to the current custodian as far as how quickly they are going to move that money over to the new company to issue this Medicaid compliant annuity. So I always let people know that if we're trying to do this quickly, then usually the 60-day rollover is going to be a quicker way to go than relying on a direct trustee to trustee transfer.
Yep.
So on Roger's IRA Medicaid compliant annuity in his name, you'll notice that Roger is going to be the annuity owner, the annuitant, and the payee. And really the thing to notice here is, since we're not changing ownership from Roger over to Nancy, and Roger is going to be the owner of the Medicaid annuity, there would not be a taxable event from rolling this over into Roger's name. Nancy, as the community spouse, can always be the primary death beneficiary on his annuity, because the community spouse can be named as the primary beneficiary before the state. And then the contingent beneficiary is going to be the state Medicaid agency, to the extent that they provide benefits on behalf of Roger. And if a tertiary beneficiary is named, it's usually going to be the children, a trust, or anybody else that they want to name after the state. On Nancy's non-qualified annuity, this is going to be the same setup as the previous example that we talked about, where Nancy is going to be the owner, annuitant, and payee. The state's going to be primary beneficiary in most cases, and the contingent beneficiary is going to be the children or whoever they want to name. Todd, did you want to talk a little bit about the financial impact of this plan?
So I think you can tell, I mean, here at the bottom, you can tell this is not the ideal situation, but in some states that don't have name on the check rule, which we'll talk about next, this is a fairly good option. And just understand, we're increasing his income, and his income always goes to the nursing home unless her income is low enough to pull some from it. And so the way that Amber has set this up kind of makes sense, in that she's kept her income so low, we're going to get about $900 per month from Roger to her. And so looking at all of this together, that makes really good sense, but it's still not as good sense as the name on the check rule, which we will talk about next. So going through these numbers, she is going to get some money from him to her, which gets her up to that MIMNA of 2643. So it's not a great plan, but it's a plan, okay?
Yeah, so if we look at here, the monthly savings is around $7,400 a month when we look at the income that was shifted from Roger over to Nancy. And so, like Todd mentioned, this is a scenario that does sometimes make sense if we're dealing with a state that does not allow for name on the check rule, and we do have a sizable IRA that is owned by the Medicaid applicant. We don't want to liquidate it and pay all the taxes up front. The benefit too, with naming the community spouse as the primary beneficiary on the IRA Medicaid compliant annuity, is that the community spouse, upon the Medicaid applicant passing, would have the option to either continue the monthly payments, or they can roll over that IRA into their own IRA with a lump sum distribution from the IRA Medicaid compliant annuity. So that's another thing to consider. Does it make sense to just liquidate it, pay the taxes, or do the second option if you are in a state that does not allow for our third option, which is name on the check rule?
Yeah. Advantages are this is safe. We know Medicaid allows this because we're not using any of the crazy rules. He is immediately eligible. Nancy gets up to that maximum or the minimum MIMNA, and she is the beneficiary. If he passes away, she's going to get the rest of his annuity. The disadvantages, if Nancy's income exceeds the MIMNA, she will not get any of his resources. So if something changes, Social Security changes, whatever, there is a possibility she would get nothing, and we're stuck in this very long annuity. And Roger is paying more to the nursing home than we would like, and so that's not a great option. I don't love that option. I would do number one, or I would do this. And so this is the name on the check rule. And so we love states. Thankfully, Arkansas is a name on the check rule, which means whoever's name is on that check, that's whose income that it is. Okay. So I kind of just spoiled that, but name on the check rule stands for the premise that the income belongs to the person whose name is on the check. It kind of makes sense, but in this situation, and I've had Arkansas, particularly new caseworkers, bring this up and say, wait a second, you took his IRA that's solely his and you're paying it to her? Well, it's still his IRA. We should count it. I was like, nope, Arkansas is a name on the check roll, and under your rules, this annuity is no longer an asset, it's only income. And with the name on the check roll, it's going to her. So this is just her income. And they're like, well, I don't like that. I'm like, I don't care if you like it or not, call your attorneys. This is the rule. And they come back and it's like, well, I don't like it, but I've got to let it go. I was like, yeah, you do. So let's go on. So now, please understand, this is not an IRS rule. There are no rules that require them to do this. This is a graciousness of the state, okay? So it is nice if your state does it, but don't get too ugly with them because they can change it. All right, next. So we take Roger's annuity and we keep it as an IRA, and we just convert it into this Medicaid qualifying annuity. And if we choose to stretch it out this way, it is still 1550, but it all goes to Nancy and is nice, okay? And the only difference between this and the other one is that it is payable to her rather to him, and since she gets to keep all of the income, that's a good thing. All right.
So the table is going to look exactly the same as far as who is going to purchase each annuity. Roger is going to purchase the IRA Medicaid compliant annuity. The only difference here with this third option and the second option is that Nancy is going to be named as the payee. It would still be structured over either 69 months or a shorter period of time. But that income is going to be considered Nancy's income instead of Roger's if your state does allow for name on the check rule. And again, we would not be mixing pre-tax and post-tax dollars in one annuity. It would be two separate annuities, one with Roger's IRA and the second non-qualified annuity in Nancy's name.
Let me just say real quick, there is a possibility that you could have three Medicaid qualifying annuities on a case, okay? You could have his IRA, since Amber said you can't mix these, you could have a case where there's his IRA, her IRA's got to be liquidated or put into the annuity, and then a non-qualified annuity. So there could be some cases where Amber's creating 3 annuities for you. Okay, just so you know.
The parties to Roger's IRA with name on the check rule are going to be that Roger's the annuity owner, he's the annuitant, and then Nancy now is going to be the payee as well as the primary beneficiary, like we saw in the last example. State is going to be the contingent beneficiary, and children or a trust would be the tertiary beneficiary. Nancy's non-qualified annuity is going to be exactly the same as the last 2 examples. And so with name on the check rule, with Nancy being the payee on both of the annuities, Roger's income now is going to remain at just $2,000 with his Social Security income, but Nancy's monthly income is going to be increased to $3,293 because she is the payee on both annuity contracts, and her income now is going to exceed the monthly maintenance needs allowance. So we're not going to get any shifting of income from Roger. So his copay to the nursing home is just going to be his $2,000 less his $50 monthly needs allowance, and we're able to get his copay down to $1,950 per month. The economic results of the 2 annuities and using name on the check rule is that the couple, again, was expected to pay $10,000 a month. We were able to reduce that down to $1,950 so that they experience a monthly savings of $8,050 per month. The advantages of this plan is that Roger was immediately eligible for Medicaid. We were able to increase Nancy's monthly income up to almost $3,300 per month. She's going to be the primary beneficiary of Roger's IRA annuity. They are going to pay limited federal income taxes because Roger is still going to be the person that is going to receive the 1099 from the insurance company, because he is the owner of the IRA account. And so the monthly payments of the $1,550 per month is going to be considered taxable as the annuity makes payments versus as a one-time lump sum if the IRA was just liquidated on the front end. Their Social Security income would not become taxable. And then the disadvantages of trying to use name on the check rule is obviously if your state does not honor name on the check rule, then that's going to be something that is not really an option in your state. We have seen a number of state Medicaid departments challenge name on the check rule and count the income to belong to the Medicaid applicant or the institutionalized person. There's not any IRS law that would, or regulation that allows for backup of this rule. Is strictly a Medicaid rule that is honored in a lot of states when it comes to Medicaid planning. This map is a map that is outlining which states we've had favorable name on the check rule decisions in, or that we've used name on the check rule without any issue. The states that are in black have unfavorable decisions, and then the ones in gray are kind of mixed outcomes just based on which county we are working in as to whether name on the check rule has been accepted in these states or not. Todd, did you want to talk a little bit about the shifting of income with the MIMNA?
Yeah, it's, you know, since we are creating income to the spouse, again, I just want to say my practice, and I think what is in the client's best interest is make this payout as much as possible, as quick as possible, particularly if her income is so low, just like Nancy's was so low, that she would get a sizable amount of money from him each month. And so again, you know, I'm going to pay this out at basically $10,000 a month, get it done and over with, and then she's going to get $1,600 from him. And so that's basically what this is saying is, you know, if the community spouse's income is over the MIMNA, then she will not receive any of his income. But if her income is under the MEMNA, she's going to get income from him. And so to create an annuity that's going to pay out, 70 months or 80 months, that's going to cause her to miss out on that $1,600 a month, I think it's just not in the client's best interest. And so just keep this in mind and just do the annuity appropriately, and your clients will be happy. Everyone will be happy. Okay.
Oops, sorry, my slides weren't advancing.
So let me just say real quick, as I mentioned, I am the creator of the Elder Law Coach. I've been doing elder law for 27 years, and for the last, I think, 5 or 6 years now, I created a coaching group that I work with attorneys across the country to get them to be pretty good elder law attorneys. Medicaid seems to be the one thing that is hardest to understand. And if all of these numbers and things, you're like, oh my God, I just don't understand, come see me, okay? I am doing a Medicaid intensive weekend. It is January 20th through the 22nd. It is all day. And when I say all day on Thursday or Friday, it is like 10 hours. 10 hours on Friday, 10 hours on Saturday, and until we get through on Sunday, probably 6 hours, okay? But I go through Medicaid from the very beginning all the way through advanced planning. I have over 100 fact patterns that people love because it solidifies points and thing. And I have a software program that you can sit in a meeting with a Medicaid client, plug in the numbers, and it will instantly give you the gift amount, the annuity amount, what the monthly payments are going to be. It does everything. And I have that for my coaching people. So I encourage you, email me and Trisha, okay? I get a ton of emails. I'm not great at answering emails, but please email me and Trisha at theelderlawcoach.com. We will get you some information. I do webinars. I'm about to do a webinar, I think in an hour, that I do for coaching. And I love to teach. I love to explain this to people. And I really love to see people leave this. And it's this weekend, plus it's 2 months of coaching calls directly with me to get these cases, understand what to do, how to process it, how to present it. And it's just a very intensive weekend. But if you want to learn Medicaid, come see me in beautiful Bentonville, Arkansas, February 20th through the 22nd of 2026. Thanks, Amber.
Awesome. Thanks, Todd. And I'll leave your contact information up here, Todd, the Elder Law Coach, in case anybody wants to email, or Trisha, any of the resources that you mentioned today in the presentation as well. I'm not seeing that we have any questions, but if people think of questions, feel free to reach out to myself or to Todd or Trisha. And I appreciate you, Todd, and everybody for joining today's webinar.
Thanks.